last program.
I think you had a question.
Oh, does someone have a question? We're going to pass it around. You don't have to wait. So once this program ends at around 5:30, you'll be able to leave. You don't have to wait to sign out. Okay, we'll pass it around during this program. So that's going to say.
Okay, so I'm on. Yeah, it's just one thing that I wanted to just check if we can do that.
Does anyone else have any other questions? But we'll be out front.
Okay. All right. Good afternoon, everybody. My name is Elan Weinreb, and I have the honor, privilege, and pleasure of having the last slot of this day. I'm sure everybody's exhausted. We're going to try to make it as fun as possible, but there's a lot of information to go through. And you'll see that we're going to be in my presenter mode. Usually this is not the way PowerPoint works, but you'll get the inside track anyway, because the outline in your materials for this particular program is basically my notes. So there's one thing that's going to have to be shifted around later on, which I found this morning. But other than that, one slide when we get to it, what you have in the outline is essentially what you see is what you get. So today's presentation is entitled Playing Go Instead of Chess, representing clients in court-annexed mediation. And Dimitri gave me a perfect segue to jump right into the substance of this program. We had a slide up on mediation, arbitration, and pro se litigants. Yeah, it's definitely becoming much more prevalent to see all three of those in modern day litigation and interactions with clients. Clients are much more hands-on now, especially because of AI and all the wonderful tools that have come on as ancillary mechanisms to AI. But in addition to that, the courts are very much in favor of ADR, alternative dispute resolution in general, because their dockets are indeed overloaded. It started really with the pandemic, but even before the pandemic, there was an issue. New York courts, at least on the state side since 2019, were always much more in the early intervention mode of trying to get cases resolved as early as possible. So before we get into the actual program, let me just take a quick poll over here. And for those people who are in Zoom land, I can't see you right off the bat. I'm sure you're going to be playing along. So you can play along at home for those in Zoom land, but I'll report from the audience over here. How many people have heard of the game chess? Yeah, right. That's what I thought. How many people have heard of the game Go? That's in, okay. Yes, also known as Wei Qi in Mandarin Chinese, as well as Baduk in Korean. So I saw a couple of hands. All right, I'd say it's about 90% over here know about chess, maybe 80 to 90%. I'd say about 10% have heard of Go. All right, and it's good because today is not going to be a tutorial on playing both of them, but it's going to be using those two games as paradigms to understand how to approach court-annexed mediation as opposed to litigation. In law school, very often, we're taught that litigation is the be-all and end-all of everything, unless you take ADR courses in law school. But very often, that's the model. Who prevails? Who wins? What are the causes of actions? What are the defenses? Mediation, however, is something of a completely different nature. If you try to use the skills and the tactics that you learn in law school, right, basically what I would call chess tactics, where you're trying to vie for upper hand dominance against the other side, sort of to speak, whoever that might be, or the other sides. Sometimes you have complex litigation. There are multiple facets to the litigation, and it gets complicated. But if you try to use those tactics in the context of mediation, you very often will be very much unsuccessful, and it will waste everybody's time. So that's really what the goal of today's program is over here. You see on the right side, while today's newly minted members of the bar, you often learn much about litigation. When you inevitably encounter mandatory court-annexed mediation, which we do certainly have in New York, the fallback on your litigation knowledge and skills to represent clients in that dispute resolution process is inevitable, because that's all you have. When all the tools that you have in your toolbox are a hammer, then everything becomes a nail. And that's a big problem. And so today, what we're going to hopefully try to learn is what the chess mindset of civil litigation is, and in terms of defining it, why it doesn't work in the Go context of mediation, And then you're going to hopefully learn how to best represent clients in court-annexed mediation and gain a significant competitive advantage, or advantages, and might be multiple, over your counterparts who have not yet attained such knowledge or such skills. Adding these skills to your proverbial toolboxes, as I said before, will probably increase the likelihood of business development and law practice revenue realization, because you will become that much more flexible and versatile in your respective practices. So who should attend this program? Well, anybody who needs CLE credit. I guess that includes everybody over here, right? But aside from people who need CLE credit and people who are going to be involved in all aspects of law, and that to a certain extent was what Dimitri was saying before, the specialization concept of law is starting to become much more obsolete in the fact that we have so much more information and tools that are out and available. So as a result, every attorney now should probably get something from this program, no matter whether you practice straight in corporate transactional deals, or whether you're practicing in litigation, or whether you're practicing in some very specialized fields such as ASpkr environmental law. The fact is that at the end of the day, there is one discipline that everybody in this room, I guarantee, practices every day, and sometimes every hour, every day, depending upon who's in your family. And that's the discipline of negotiation. All of the legal disciplines that we have, whether you're doing transactional work, litigation, mediation, arbitration, neutral evaluation, settlement conferences, they're all different. We're going to be discussing each of them a little bit as we get through the program, but all of them are founded upon negotiation and communication, two very much least common denominators of everything that you do. So mediation is really facilitated negotiation. We're going to come up with a more concrete definition of it later on. But at the end of the day, that's how you could define it as a shorthand. And since you negotiate every day, it comes down to you negotiating with your loved ones, you're negotiating with your employers, those people who might be below you in terms of being junior associates later on. It doesn't make a difference. You're negotiating. Right? People who are religious negotiate with God. So you're constantly negotiating in everything that you do, and therefore this program is very useful for attorneys to attend. All right. We're going to divide today's session into 4 parts. The first is going to be what you don't know can hurt you, and we're going to discuss the fundamental differences between chess and Go and why that civil litigation chess mindset fails in mediation. We're then going to discuss preparing to succeed in mediation, properly preparing your clients and yourselves to succeed in that discipline of court-annexed mediation, although I will say that a lot of the skills that you're going to be picking up today and we're going to be discussing, they can easily be exportable to private mediations where you don't have a court standing over you. The real issue with court-annexed mediation is that you had a set of rules and regulations which are constraining your time, as well as that of the mediator, as well as that of the other side, or sides for that matter, to get things done within a certain period of time so that the court's dockets can, amongst other things, be alleviated from the burden of litigation. In private mediation, there's much more room, especially if it's pre-litigation. So there's some things which are going to be different about it. But for all in all, in terms of the mindset, you could take those skills that we're talking about today with court-annexed mediation and export it to private. Part 3 will be then the initial session and beyond, when we're actually getting into the mediation session itself. That's going to be involving the Badger framework. If anybody has ever run into Professor Leela Love from Cardozo, I know we're in New York Law School, right down the street. It's the rival school. The fact is that there are a lot of fine professors at New York Law School. I actually happen to be an adjunct to Professor Theo Cheng, for those people who have been in his ADR dispute resolution processes survey course. I've acted as a mock mediator and arbitrator in those courses. So both in the intersession as well as in the spring. So the fact is that they're just phenomenal people all over. Professor Chris Franklin, also, if anybody is an NYLS alum, she's phenomenal as well. But we have Professor Leela Love giving us the Badger acronym, which is a shorthand for the mediation process. So we'll go through that so you basically understand the elements involved in that mediation process, how to work within it, using things that you probably will not be using straight out in litigation, like deal math. Those people who are in the corporate transactional environment would probably definitely be using this, because the goals of transactional work, even though they're founded in negotiation, are very much different than litigation. You're not looking to prevail, you're looking to synergize, which to a certain extent aligns more with the Go mindset. And then finally, we're going to discuss very briefly, time permitting, I say we're already 8 minutes in, when mediation doesn't settle, it's as Yogi Berra used to say, it's not over until it's over. can you take some of what you've adopted or adapted into your litigation, or for that matter, even a pre-dispute conflict, and then use it to go forward in the litigation process, maybe picking up another process like arbitration instead of litigation to better maximize value and efficiency for your clients. Okay. We've gone through these objectives essentially on the previous slide. So I will just give you a better set out over here, and you can see this slide later in the materials. And then this is coming directly from the outline, and I do want to, get right into things. So we're going to move on. Okay. So what you don't know can hurt you, and we're going to define here now the core differences between the games of chess and Go, in about 1 minute, give or take, and how they perfectly parallel the differences between litigation and mediation. All right. Chess. King's on the board, kill the king. That basically is what chess comes down to. Yes, oh, how hideously oversimplified have I made the game. But at the end of the day, you want to hear that one magic word, checkmate. All right. And the king is about to go down, and that's the end of the game. You win. All right. Power, dominance, aggression, conquest. That's what chess is ultimately about. Interestingly enough, I've always seen these law firm ads. I love it where they show big chess pieces, huge chess pieces, and they have a king. Anybody who plays chess knows it's the queen that's the most powerful piece on the board, right? So I don't understand why they keep using the king. They should be using the queen. But all right, the objective of the game is still that. In Go, all right, in the mediation framework, or the Go framework is used in mediation, instead of focusing on power, aggression, and conquest, the focus is more on balance, dialogue, and maximizing resources. The game, interestingly enough, ends when players agree to stop. So it's much more about a consideration of general circumstances, of clients' needs and interests, than it is about specific positions and finding out who wins. Because sometimes you can have what's called a Pyrrhic victory in litigation, where you essentially have expended so much resources on behalf of your client has paid so much that you've greatly exceeded the amount in controversy, and all that anybody is going to do is essentially send your kids or someone else that you know, or they're the other side's kids, or if you're not people who have kids, then it's going to be putting your vacation on your finances, whatever it is, it's enriching the lawyer's pockets, putting it like that. And it becomes ultimately an openly inefficient outcome. So without further ado, I'm going to give you this now short video, which I think everybody heard the preview of before. It literally is short. It's about a minute. And here it is, the differences between Go.
Go is so much better than chess. But honestly, you cannot compare them because they're very different games. Chess is about power. You have kings, queens, and knights. It's a literal hierarchy. You win by killing the king. It's linear, it's violent, you play to conquer. But Go is about balance. There are no different pieces, every stone is the same. No special powers, only position. You don't win by killing someone. You win by making space and by learning when to let go. In chess, one single move can change everything. In Go, it's the accumulation. Thousands of quiet decisions. It's not about outsmarting your opponent in one blow. It's about understanding the board the whole time. Chess punishes hesitation. Go rewards you for patience. And maybe that's why people fear of playing Go, because it doesn't just test your logic, it tests your ego. So yeah, chess and Go are not even the same universe. Go is so much better than chess. But on
Don't you love it when YouTube just repeats everything, so something like that? But there you go. And try to catch it on time. I obviously was not so successful from that, but there you have in 1 minute the differences between the two games. Now, so I have in my notes over here, we could easily spend this entire CLE session learning how to play the two games, but I think you get the idea that Go is much more circumstance universe oriented, and trying to consider everything that's going into play in terms of a litigation, in terms of a dispute, in terms of a conflict, and you don't have that with chess. Okay, I think everything else that we have over here is what we said, so we'll move on. All right, now, when we come to defining the terrain of litigation and mediation, all right, let's take a look now at the differences between Go and chess and use them as parallels to the two processes. They're both dispute resolution processes. We both have, at some point, a dispute, a X versus Y scenario, or sometimes more, and you're ultimately coming out to someone making a suggestion in the case of mediation, or the parties themselves coming to that suggestion, or alternatively, you're looking at an adjudicator, you're looking at a decision of fact finder, but either way, you're looking at resolution. So they are forms of dispute resolution. The question is, what's really the difference? Well, in mediation, we have what's called collaborative dispute resolution, where the parties are coming together to try to work things out by themselves. That is essentially facilitated negotiation. If they're doing it just by themselves, that's negotiation. You don't like the goods that I sent you? Oh, they were moldy or something like that? Okay, I'll give you a credit. Yeah, we're all good. Let's go on forward with a contract. Wonderful. All right? Rarely does that work in real life for a bunch of reasons, some of which, by the way, are just emotional. People sometimes have long-standing relationships, and certain expectations have been built up, and then those expectations get frustrated, and a lot of things in terms of damage to the relationship drive an almost a domino effect or a cascade failure. Let's load. Move this down a little. Just bear with me. I think that's a little bit better, so you'll have less of the feedback. With respect to mediation, again, you're using facilitated negotiation. You're bringing in a third party to come in and try to decide, not really decide, you're getting the third party to come in to suggest resolutions, to generate creative options so that the parties ultimately can come together and resolve their disputes. Litigation, on the other hand, is the complete reverse. Both the parties, the complete opposite, I should say. Both the parties are completely disjointed from each other. You have counsel, very often you have attorneys representing the clients. Even if they are pro se's, they then become their own attorneys. But either way, there's very much a whole set of rules, regulations, formalities. And then you have a judge or some other fact finder in that position, a justice in the Supreme Court, who's turning around and saying, this is what the law is. This is what the rights of the parties are. This is what the remedies are. And guess what? I don't care about your situation. I don't care about your situation. I care about two things: injunctions and damages. Okay? That's basically what you have in the realm of litigation and the current era, the litigious era that we have in the United States, and what you're taught in law school, which essentially is that people go and they fight it out to the death, sort of to speak, and economically speaking. All right, litigation is court-driven. As I said before, mediation is party-driven. Right? So that's the big difference between the two of them. Go and chess. Chess, right, there is no court, but on the other hand, it's a response. It's a tit for tat, sort of to speak. On the other hand, Go, when you're trying to engage in a dialogue with the parties, is much more flexible. Right? It's not necessarily something which is proportional. Sometimes you have a very small move in mediation, which is made by one party, which is very gutsy for that party to make, but suddenly it just almost like breaking the floodgates open. Suddenly after that, the mediation resolves in an hour. And you could have the 7.5-year dispute that's been going on, which has been very bitter, resolved in a matter of hours when litigation just doesn't do the job. Litigation is past focused. The parties really are looking at what was done. They don't really care about restoring relationships going towards the future. Go, on the other hand, is again, balanced dialogue with the party. You're not trying to dominate the party. You're trying to come out with the most efficient realization of whatever resources and circumstances you're given. Can we just get it down so we don't have as much feedback? Great. With respect to, we said before about decision-making, the litigations, the judges decides prevails. Thank you. And in the litigation, we also talked about the remedies being limited. All right. Has anybody seen this graphic before? Good. All right, wonderful. This is a great graphic which was produced by the New York courts a long time ago, although if you go to that first URL that's down there, you're not going to find it anymore. For whatever reason, they took it off their website. But what it is, it shows you an ADR continuum, right? Showing you where we have essentially collaborative dispute resolution on the left side, moving towards adjudicative or adversarial dispute resolution on the right side. Mediation and early neutral evaluation, you see there in highlights, over here, they are, where's my pointer? They are right in the middle. All right, they are right in the middle of the spectrum. When you're deciding with the other party yourself what should be the outcome, obviously that's the most collaborative process in terms of resolving a dispute that you could have. And when you have on the flip side a court deciding what the rights and remedies are, everybody, that's the most adjudicative or adversarial process that you have. But in the between, you have mediation. And what aspects of mediation are more akin to litigation? Well, you have that third party. You have the mediator or mediators. Sometimes you have a team of mediators that are working together. And what's not is that you don't have a binding decision. That's really the major difference between the processes. There are others, many others between the two of them. Again, formality, and you'll see that we have as we go through the spectrum, you'll see there are similarities between each rung. There's more similarity between negotiation and facilitation, which is less intensive in terms of using a third party than mediation. Mediation usually involves briefs as well. That's something that you don't necessarily have in facilitation. But it's not the same thing as when we're getting to early neutral evaluation, which I'm not going to discuss extensively over here. Otherwise, we're going to completely run out of time. But that's where you have a process where you're basically trying to settle the case within the rubric of the law. And you're not so much looking at the party's needs and interests and things that are outside the law, that are outside of the box. So the box, sort of to speak, in terms of rights and remedies that you have in litigation begins to form when you get to early neutral evaluation on the spectrum. After that comes arbitration. And we heard Dimitri speaking about that before. Arbitration, very often people view that as being litigation light. It's not. I tell you, I'm a AAA arbitrator. I currently have a case in front of me. It is not exactly the same. It moves much quicker, and there is much less formality than you have in litigation. But at the end of the day, the arbitrator is still making the decision, and you do have scheduling orders and a bunch of other rules that you have to follow. Okay. All right. Why specifically do the chess tactics fail in mediation? Well, the biggest reason is because when you're dealing with litigation tactics, this person did this to me, I want to find out what's the biggest dirt up on the other side, and I want to use whatever I can to dominate. The fact is that doesn't do much for generating trust and goodwill to try to resolve the dispute together. It's completely at cross purposes. If you're sitting aside from the other person and they're saying, yeah, we can work this out. You're going to give me everything I'm asking for in my complaint or counterclaim, whatever the case would be. And then you're going to, in addition to that, pay for incidental, consequential, and punitive damages. And then I think we have a mutually amicable resolution of this dispute. Yeah, no, something about that just doesn't jive, all right, in terms of the way that things work out. So that's why chess really doesn't work with mediation and in terms of using the go paradigm, because it doesn't lead to any dialogue, right? It leads to dominance. When you're using those types of tactics in a process which is about dialogue and balance and potentially restoring relationships or even fostering new relationships, it just doesn't work. It's like what you see on the bottom over here that I have. You can't mix oil and water, and a different approach to that is going to be required. The other reasons why is because when you start using chess tactics in mediation, you start saying, this is my position, this is where I'm going, you don't have movement. You're creating that box that I spoke about before. You're not allowing for your clients, and for that matter, for the other side, to be understood. And that's the idea, ultimately, in mediation. You're trying to understand where the other side is coming from and to realize where a breakdown in communication has occurred. Because every dispute, as Dimitri was sending out before, does involve some aspects of communication, and very often it involves the breakdown of communication. There's a misunderstanding of expectations, there's a misunderstanding of logistics, and the list goes on and on and on. But figuring out where those breaks are, and then going from there requires, if you're going to be in litigation mode, great. That requires dominance. It requires essentially shutting the other side down as much as possible with completely unwarranted discovery requests and with the other inefficiencies that are created inevitably by litigation. Or if you're adopting the go side, then it involves opening up an understanding with the other side to try to see where everybody is and coming together. Again, if you're going to be using chess tactics in that environment, you're not going to get anywhere. It's complete like oil and water. The other point is this: whenever you're going to be using chess tactics, you're going to be engaged in something called, or you're warranting, reactive devaluation. Reactive devaluation is simply, I am not going to accept what you say because you said it. I will not give any credence whatsoever to understanding the objective facts or any of the other variables, and even to the extent that it damages me. If you tell me, how about a deal where I'm going to pay 50% of what you're asking for, and we could go our separate ways, and then I think to myself, well, he's suggesting that there's got to be something wrong with it. So no, you're going to pay me 100% afterward, specifically because you're the one who made that suggestion. The mediator or mediators in mediation are very much instrumental in short-circuiting reactive evaluation, because if you can get your mediator to effectively craft a proposal that maybe has his or her input along with the initial proposal that's coming from the side that wants to settle the dispute, then it's not ultimately the other side, it's the other side plus the mediator or mediators. So in that case, using a more open mindset will work to short-circuit reactive evaluation, which can prevent, of course, an efficient resolution of a dispute. All right. How do we prepare now, since we've discussed the differences in the tactics, right, and the mindsets between chess and Go, between chess being litigation and arbitration, and Go being more of the mediation, facilitator negotiation framework? How do we adequately prepare? Well, this is a seminar on court-annexed mediation. So the first thing that you need to do is, in any environment when dealing with a court, is read the rules. Okay? We do have new rules now in New York. They were enacted in February 2024, so they're not so new anymore. They're almost 2 years old. But it applies, that's part 160 of the New York Rules of the Chief Administrative Judge. And it introduces a new framework. At the time, it's not so new anymore, but it's still out there for trial courts. The idea being is that mediation should be used to resolve cases as early as possible. And there's good reason for this. The longer a dispute ends up stagnating, right, the harder it is to resolve. More money is expended, more sunk costs are put in. There's something which we're going to be talking about called the endowment effect that starts to take hold, especially when attorneys start coming up with very creative legal arguments, which definitely attorneys should. There are certain cases, by the way, I'm just going to say, not every case is appropriate for mediation. There are certain cases which have to be litigated. There are certain cases which have to be arbitrated, and you'll know them very, very quickly. You won't give any traction, and believe me, as a mediator, I absolutely cannot stand when the courts assign me those cases. Thank God they've been very few and far between. But typically, there are no-pay cases where one side walks in and says, no matter what you say, no matter what you do, we're not paying them a dime. Those are the types of cases which very often just unfortunately have to be litigated. Even when the attorneys, by the way, can agree by looking to jury verdicts and a bunch of other variables, and when they do the work, sometimes, especially insurance companies, they're known for this, but other litigants as well, they'll be so steadfast and adamant that it's impossible to resolve those cases. But most cases can be resolved through mediation. Last time I checked the statistics, 85% of commercial cases were successfully mediated when they ultimately were sent to mediation. Given the general settlement rate, right, well, that's the question of whether you're not using mediation at all, just the general settlement rate at all was approximately 93%. You're not really looking at too much of a differential. So the courts, looking at the statistics over here, decided let's go forward and put in early presumptive mediation that's mandatory. Little bit of a problem there, right? Mandatory mediation. That's somewhat of an oxymoron. Mediation is supposed to be, if you study it, voluntary. The parties are supposed to be coming together. They pick a mediator. That mediator is supposed to help them make decisions by themselves. And now we have a court telling you, well, no, you have to do this, and this is the time they're in that you have to do it. Now, the answer to this is that the process can be mandatory. The substance is voluntary. In other words, the courts can tell you, you have to go to a mediation session for 90 minutes. And if you don't, there's going to be sanctions, there's going to be penalties. But within that 90 minutes, you can do whatever you want. So I've been to mediations where people have used those 90 minutes and then have gone beyond them. We'll talk about what happens when you go beyond the 90 minutes very constructively. And there have been to such, unfortunately, not too many, thank God, at this point. But when I was first starting out as a mediator, I went to sessions where people literally had timers, like the one we have going up over here, and they were counting down the minutes. 90 minutes, 89 minutes, 87 minutes. And they would tell me at various points, oh, by the way, you have 84 minutes left to go. You know, might as well get to work on settling the dispute. And I would tell them that's not ultimately my role over here. The goal of me is to try to get your respective clients, and when the attorneys were telling you that, to set the, to resolve the dispute. But the rules are still there. So we can have 90 minutes of mandatory mediation in a lot of places. Other places, it's 3 hours. You know, it depends upon which court you're dealing with. If you're dealing with Nassau County Supreme Court, which we're going to look at their rules in a minute, you can very easily see that they ask for 90 minutes. If you're talking about New York Commercial, down the block over here, they're up for 3 hours, all right, in terms of free time, which is given, and what they ask the parties to attend in terms of mediations. Those cases obviously are much more complicated, so it makes sense. But the general standpoint is 90 minutes. That seems to be the way things are going right now. All right, so up in front of you now, you have a statement of the rules of the Civil Case Alternative Dispute Resolution Program. These are very similar, by the way, to the commercial rules, all right, as well for Nassau County, but they define the process, all right? It is incumbent upon you as counsel to read these, to know these, and then I dare say to, in some cases, memorize these, because to the extent that the courts have certain timeframes, they really do not care. Now, that's not to say they won't give you some flexibility, but believe me, the ADR coordinators, the people who are in charge of administrating these rules, they know them very well because they are the people who write them, and then they get them approved by the judges who are above them. Fact is that if you want some variance in terms of the time, right, even if you're the mediator, right, it's incumbent that you make the request early, not, oh, it's a 45-day time frame, and oh yeah, the courts really don't care about that anyway, so we'll just go forward. Now, sometimes you can get lucky, but other times you won't, and then it could be a problem, right? Because everything that is involved in terms of the process aspect of mandatory mediation is potentially sanctionable. Do you find a lot of times when people are going to be sanctioned? No. All right. The fact is that the courts are very forgiving. The administrators are there. But on the other hand, if you have a certain set of judges or a judge who's known for being very adamant about moving cases to trial, especially if the case has an index number going back 10 years and they need to clear things on the docket, well, guess what? You can make all the requests you want, even as the mediator, even when it's jointly agreed, and the judge who is in charge of the trial part and assigning will say no. And you'll unfortunately lose out on an opportunity for that. So it's very important to read through the rules thoroughly. I want to just get to the rule, which is going to be probably the most spoken about by your clients. We are going to be discussing, by the way, the pre-ADR statement. That's very important in terms of your preparation. Under court rules, they're required in some aspect or another, although mediators can and often do modify the type of statement that's going to be submitted. But I want to just highlight over here Rule 6, because everybody asks about this is in terms of practice, and this is a practical CLE, we're talking about skills, and that's compensation. How do mediators get compensated? Because after your clients have paid you and after they've paid whatever fees the courts have imposed upon them, and we're talking obviously about a litigation that's full blown over here, and they've been, let's say, involved in litigation for years on end, their question is going to be, why do I have to pay someone else? And the response is, you don't have to pay the mediator anything because we only have to do this for 90 minutes, right? That's what the rules say. Let's take a look. Parties shall not be required to compensate the neutral assigned by the court from the program roster for services rendered during the 90-minute initial session or for time spent in preparation for the initial session. So until you go to that first mediation session and you sit down either in person or virtually with the other side, you are not going to have to pay a dime for, of course, to the clients for doing that. If you're the attorney, yes, of course, you could bill them for preparation for doing that. It's a little bit of an asymmetry, but that's the way things are. Right? After that, in Nassau County, at least, there's a cap, $450 an hour for the mediator or mediators' services. If there's multiple mediators, they split it. So it's in that aspect, it's limited. But people think, what do I need to pay someone else for this process? And now it's incumbent upon you as the attorney to do what the mediator tries to do, but very often cannot be successful in just meeting with the parties initially, what's called the pre-mediation conference and the PMC. And that is to really recognize the value of the process that we have over here. If you have a mediator who's going to be working on a case, he or she does not want to waste his or her time, even if he or she is doing it pro bono. Even if she or she says, I'm retired, I don't really care about getting compensated. The fact is that no one likes to waste their time for doing that. So mediation should not be viewed as something which is let's just get through this and move on. All right? If really that's the way you feel, go to the mediator and explain your concerns to him or her, put it right out saying, we're not going to be taking any positions where we're going to have any movement. Fine. All right. In that situation, sometimes the mediator can then get you out of it. But don't go through the mediation process just as something by rote. You're squandering a tremendous opportunity here to resolve your case, and you're doing a disservice to your clients. To that extent, there might be ethical implications involved with all of this. But people always ask, when does the compensation start? Here's the quick answer. It starts at the end of the 90 minutes of the first initial mediation session, where people are coming together, again, either in person or virtually. Okay. The timing, and you see there's many aspects of the process, which I will let you, read from just clicking through the link. But conflicts of interest, of course, it's a neutral process. So to the extent that there are any conflicts of interest that have to be disclosed, the mediator should be disclosing them, him or herself, as well as you as attorneys. Don't have it that, oh yeah, I know this guy, he was someone who I knew previously, and then you're ending up with the other side figuring out that no, there really was some aspect of neutrality, which was a problem, and then mediator is put in a pickle. Usually the mediators will very often disclose. I mean, that's why I run a conflicts check when I have a case, but it is still very important. And then communications with the referring justice. This is different, by the way, with every court. There's some courts that prohibit the mediator from communicating anything about the process with whoever the referring justice is going to be. Other courts allow it. So you see the rule over here with the Nassau County setup is that the neutral may communicate with the referring justice about administrative details, but not necessarily about substance. All right, so getting back to the rules, that's what you have to do first, right? Next, I explained before about mediation economics, right? You should explain to your client the importance of mediator involvement and the value he or she or they, if it's mediators, bring to the table, and the importance of the compensation. Once you've done that, you read through the rules, you have gone through the basic economics, and now your clients are maybe more willing to pony up some more money for a process that can get them out of the litigation or the disputes they've been involved with so long. Then the next thing you have to do is you have to do what I just did before. You have to explain the differences between mediation and litigation and arbitration to your clients, because they don't know it. You know how many times I've had people who are pro se say, yeah, Your Honor, it shouldn't be a title used at all in mediation. Yeah, Your Honor, how do I go about winning this thing? How do I go about winning this mediation? There's actually an article which I have cited from your materials called Winning the Mediation versus Resolving the Dispute, which answers this. It's unfortunate people, just do not have any understanding that mediation is a non-binding process. It's not the goal of the mediator to decide who wins or who loses. The mediator is on nobody's side, and the mediator is on everybody's side at the same time. Again, to try to bring the parties together in a dialogue. So it's important to set the structure when you're representing clients in court-annexed mediation and understand the process that they're getting in. Then, all right, we said before, major difference between chess and go between litigation mediation is the focus on the past versus the focus on the future. Sit down with your clients and ask them one very basic question, which often does not get answered very accurately or specifically. That question is, what do you want to achieve? That is an extraordinarily important question that very often most attorneys just go right by. We're in litigation. We know what we want to achieve. We want to achieve $1 million. Whatever's in the complaint. Oh, we read the complaint. Sure. No. You have to get into your client's shoes. You have to get into your client's, not only client's shoes, you have to get into your client's heads. You have to see where they're coming from, what's going on in their lives, what are their burdens, what are their responsibilities. All of that comes into the go board. It doesn't come into the chessboard at all, but it's coming into the go board because these are things which very well might be extraordinarily important. Oh, your client, do you want to pay $1.8 million to resolve $1 million dispute so you could have the satisfaction and saying that you won on the principle, but still be $800,000 in the hole? Yeah, I'd like to see clients like that. Great. If that's the case, my response is, please give me $100,000 retainer. Now, the fact is that you're not going to find too many people like that, but they don't understand what's going on. So it's very important to get the goals right up front. And you should be doing this, by the way, even before you get the notice of order of reference or cases going to court-annexed mediation. When you sit down with your clients, right, whether it's even when you're doing transactional work, even, especially when you're doing transactional work, most dangerous deals that you have between corporations, between individuals, are those in which the parties really don't have any idea of specifically what they want. Oh yeah, we want to create synergies to market these products and to generate money, and we're all for capitalism. Great, yeah, okay. I'm all in for world peace also, but that doesn't mean that because I want it, I'm necessarily, going to get it. It's the same thing that you have in terms of the structure of deals, in terms of identifying what the client's goals are and what they want, as well as in litigation, figuring out ultimately what they need to achieve and what they want to achieve. All right. Positions versus needs or interests, we'll discuss this a little bit later, but it's important to wean clients away as you get ready for mediation into the mindset of, I want to achieve a more general goal, right? I want financial security. I want business certainty. I want something which will allow me to achieve my goal of going to Tahiti, later on. Now, the difference between that and I need or I want $200,000 is enormous, because there are many ways to get to a general objective. And you could think outside the box. You could be creative. You can't do that when it comes straight out to money. Money is what's called a distributive variable. It has to be carved up. It's no real way of dealing with it other than it's a means for getting something. Very often, one of the best questions that a mediator can ask, and I know this is for you as advocates to represent clients, but just to put this in perspective, try to get into the mediator shoes. One of the best questions that a mediator could get is, all right, let's say you have, say you have someone who's adamant about their $200,000 position. What do you want to do with the $200,000? How many times have I gotten puzzled looks on people's faces? Let's say they dropped to $200,000 and, oh, well, I'm going to get satisfaction from that. No, you won't. You're going to get fees. You're going to get other things. You're going to have other expenses too, like that. No, money doesn't buy happiness. Money doesn't necessarily buy satisfaction. Oh, well, I want to make sure that I get a certain return on my investment, which I put in because I dedicated my life to this company. And I want to make sure that that all the hard work and effort that I said, okay, wonderful. How about a profit sharing plan going forward? Why do you specifically need $200,000 right now? Why don't we give you some stock options later on? Maybe those will be much more valuable, especially given whatever this company has in the pipeline. You're not going to get that in litigation, right? So again, find out what your clients want. What do they want to achieve? It's an extraordinarily important question. And then the last thing really in terms of counseling, prepare your clients to do something which probably most litigators are very fearful of, and that's letting them speak for themselves. Yes, mediation, we require that sometimes the clients, well, we can't, as mediators, make the clients speak. But the idea ultimately behind a successful mediation is that the client's voice comes through. Sometimes you have clients who are timid. Sometimes you have clients who don't feel that they can express themselves adequately, fine. But then you have to become the client. You don't have to turn around and become them to the extent that you're living with them 24/7, sort of to speak, but you have to be more than their attorney in those circumstances. You have to give them a voice. And then if you do that, you'll find out that they will be able to express themselves that much better at the mediation sessions when you're in joint session. All right? It's also important with respect to caucuses or private sessions. Now, we talked about before the endowment effect. The endowment effect is very simply something that we ascribe greater value to that which we own. All right? Today, all of you have dedicated hours at attending this wonderful CLE program and these sessions. So you are endowed. You've already sunk in your time. You've sunk in your Sunday. You're not getting it back. All right. So congratulations one way or another. Hopefully you have a couple of laughs and some fun and games, literally, with this presentation at the end. But the idea is that if you are endowed with something, you want to get what you view as being appropriate value for what you put into something. If you study for a test, if you end up working on a case, right, you expect to be compensated. If it's a matter of the academics having a great grade, it doesn't make a difference what it's going to be. If you put in the time, if it's a toddler's Lego project and you've spent 16 hours reading through the pictorial instructions and still can't figure out how to put X1 with X5, and your little toddler is screaming about it. Guess what? When you figure it out, you're endowed. You did it. You are the hero. Yeah, so that is the point of the endowment effect. People very much, when they have resources, money, time, effort, sweat equity, when any of those get put into some object or construct, they are very much going to be hesitant to give that up or to have to sacrifice what they've built up. So it was a term which was coined by Richard Thaler in the 1980s. They own, sort of to speak, their claims and defenses. And this, to a certain extent, is a big problem because it interferes with objective analysis of the case and the true valuation of the case. Right? And by the way, let me just make a quick point. When we talk about case valuation, people are like, oh, what's the case worth? Oh, yeah, okay, well, it's very simple. Well, you have an X percentage prevailing in this cause of action. This defense isn't going to hit home. We probably could get something over here. Maybe we could get punitives. All right, let's go through a probability grid, what's called a decision tree, which we'll look at very briefly later on. And that comes out of that. No, that's case valuation for trial. All right, that is ultimately what a case is worth from the trial perspective, which is great. If you're a litigator, you can do that. But if you are getting involved in the mediation process, you have to go above and beyond that. What is a case worth to a client in terms of settlement value? How much money will you save by settling a case today than moving everything forward? Those are questions which are very important to a client. Right? Now, to a certain extent, some attorneys, they get very fearful of asking those questions because they take a look at ADR and then they say that it doesn't stand for alternative dispute resolution, it stands for alarming drop in revenue. Right? Because they figure, oh, we settled the case, that's a disaster. But the fact is that at the end of the day, even if you short circuit a case with the use of mediation, those clients will realize the value that you gave them. They will come back to you. You will get repeat business from them, and then they'll start spreading word by word of mouth. This attorney is not looking just at the end game in terms of the litigation. They're looking at the whole picture. They're looking at the go board. They're not looking at the chessboard. You will make more money by being more efficient. All right? Just trust me on this. It's what people ultimately nowadays want. People are not, with very rare exceptions, people are not professional plaintiffs. They're not professional litigants. They don't want to spend all their hours and time in courts. Corporations don't want to have to spend the time sending out their employees for depositions and then having to go engage in massive document productions, which have gotten so expansive nowadays in light of ESI and other discovery obligations that you have as part of the litigation process. People want essentially quick, efficient, expeditious ends to their disputes. That's what mediation can give you. Again, playing Go, not playing chess. Okay. How do you counter the endowment effect? Well, first thing is to use objective benchmarks. Right? Look at things in a global picture. If a claim is worth $285 and the client is seeking $285,000, problem. All right, from doing that. Yes, there may be some statutory damages, exemplary damages, maybe some punitives coming from something like that. But in terms of that case evaluation, you're going to have a major issue for doing that. So use the law in that aspect, right? Center your clients as to when they tell you what they want. First, see that if it's realistic, right? Next thing you could do afterwards is reframe the narrative. Say to them, look, instead of looking at this from the perspective of I put in this, I put in that, why don't we look at the other side? Why don't we try to understand where the other side is coming from? Didn't the other side sacrifice certain things? Aren't they also endowed? Do that, and sometimes clients will start thinking, okay, maybe I have a point, especially in business partnership disputes. It works very well, especially when you have 50-50s right on the dividing line, and you have, which is a disaster, by the way. Anybody who's doing corporate or transactional work, if you have an operating agreement or a shareholders agreement, please make sure that there's some sort of tie-breaking mechanism in terms of votes that are set up. Do not leave shareholders or members or partners, as the case may be in whatever business organization you're doing, in a 50-50 scenario. It is a recipe for disaster. All right, so that's just some advice in terms of structuring deals. Third, involve neutral voices. Right? Bring in someone who's a third party. If someone is a spousal dispute or if it's a family dispute, bring in someone, Uncle Phil. Might be Dr. Phil at the same time, but bring him in. Right? See what bring her in. Bring Dan Betty in. Whoever is going to be a person who's the voice of reason over here. Get them out of the mind frame that it's just about them. Right? Because the endowment at the end of the day, the endowment effect at the end of the day is about selfishness. It's about thinking that they are the ones who are controlling everything. And that, yeah, there's certainly going to be something to be said for whatever value or whatever effort someone contributed, but it's not necessarily going to be as extreme as they think. Cognitive biases, all right? There are many of these. We actually have 4 of them. One of them is going to be, you can see I'm coming up on the next slide, the sunk cost fallacy. I discussed that today. Anybody who feels that today was a drag, hopefully not, right, will feel the sunk cost fallacy that essentially I spent so much time, I spent so much effort getting ready for this whole thing, and now I sat through the whole day, and what did it get me? It got me CLE credits. All right, you know, for doing that. Another point is reactance. That is a cognitive bias. Just because the other side said it, when I'm in doubt, yeah, I did this, I did that. They didn't do this, they didn't do that. Whatever they say, garbage, right? Problem. Confirmation bias. Ignoring evidence that contradicts ownership of the claim. You can start looking through everything. That's what's called the rose-colored glasses bias. Right? You start looking through everything and you start seeing everything through rose-colored glasses. Oh, I was the one who ended up doing this, and very often things are not always that clear cut. Right? The rose-colored glasses sometimes have to be freshened up with eyeglass cleaner. And then another bias that you have is anchoring. When you have your initial consultation with a client, you get them fixated on a number. Yeah, I read this case, I read that case. I ended up doing a survey of the law in 50 states, whatever research you've done. And I'm sure with AI and what else, it's going to be absolutely stellar. But then you tell your client, this is the number we should be seeking. You know, we're probably not going to get it. It's pie in the sky, but yeah, $2 million, right? Once you say $2 million, congratulations. You've just put that number in your client's head and it will stay there, all right? And God forbid, by the way, should you guarantee, do never, ever guarantee that you are going to get them $2 million. That is a recipe for a malpractice suit. Right? It's like that. But very often, clients hear numbers, they go right for that, they're anchored. They get just like a ship's anchor. Think about the same thing. You anchor a ship, first time you set it down, that's where they are. All right. It happens, by the way, in the mediation sessions as well. We have anchoring, and it's very important how to make the first move. But we're not going to get into actual tactics today for doing that. I'll have to say that for another time. Another way of getting rid of the endowment effect or mitigating it is ask how much the client would pay for the claims if he or she or it did not own them in the first place. Right? What if you were, again, standing outside this whole dispute? What if you were me? Ask them to consider, better yet, what if you were the other side's attorney? What if you were the other side? How would you view that? This what if you were the other side can be very difficult to do with a client, at least initially. What if you were the other side's attorney is a very good question, because they're seeing then how well you've assessed the other side by doing that. And if they are presented with more objective information, they will often start coming out of the entrenchment which the endowment effect creates. 6, raise the buyer or seller's remorse in not settling. All right. If we don't settle the case, what's going to happen? Oh, we'll be in, I mentioned this before, we could be in litigation for another 10 years. Oh, great. I'm going to get rich as the attorney. What's going to happen to you? Are you still going to be able to pay my bills? I wrote over here the story of Solomon's judgment in the book of Kings. And keep in mind here, I wrote from the viewpoint of the child's mother, the true mother. Now, for those people who aren't familiar with the story, I'll just give you a very quick recap. You have 2 women who both have given birth to 2 children. This is in the age of the ancient world, so unfortunately, these women were not well taken care of. I'll just leave it at that, but they didn't have husbands at the time. And one of the children ends up passing away in the middle of the night. The other mother is fortunate enough to get up, the one who didn't have her child die. She ends up taking the child, and since they were born about the same time, there was no DNA testing or anything like that we have today. She claims it's my kid. The other one, of course, gets up, and what does she do? She takes her dead son and puts it into the other mother's bed, and then the other mother wakes up. She sees, unfortunately, this dead child. Mother knows her own child, right? But they can't resolve this. They can't go and come up to some resolution, and the mother who unfortunately took the child who was living is not going to fess up. They go to Solomon, King Solomon at the time, wisest of all men, as the Bible tells us, and they ask him, what should we do? And he says, bring out a sword. What we're going to do is we're going to take the living child and we're going to cut him. We're going to cut him straight through. 50% goes to you, 50% goes to you. Typical litigation remedy, right? Well, you have a resource. Yeah, I can't figure out who owns it. All right, the law says in cases of doubt, let's just divide it up. It's the easiest way of dealing with it. We'll go Solomonic. That's where the term comes from with that. The mother of the child who was living says, no, give the child to her. Give him up because, right, it is a living being. She doesn't say it is my son. He uses the word, by the way, in Hebrew, which is used as yilod. It means the offspring. Give the offspring because she recognizes the value of human life. right? That, to a certain extent, was a complete evisceration of the endowment effect. Obviously, a mother is involved, is endowed with probably nothing more in the world than the birth of her own child. But in this particular case, she was so taken aback by the prospect that her child would die, right? In this case, that she let that go. She forsook the opportunity to raise that child, to see him grow up. And instead, she would give her over to her adversary for the purpose of preserving his life. And that was her value. What happened was there was a transition from becoming my son, from my son becoming the child which has been born. So try to do that also with the endowment effect. See if you can come up with some way of evaluating the scenario differently so that certain priorities may take precedence. Let time work, 7. If you have it and it's a long-running litigation, eventually as time goes on, it just doesn't become worth it anymore. This is what we're talking about by the Pyrrhic victory. That can work as well. Lawyer self-awareness. Right here, as an attorney representing clients in court-annexed mediation, you got to really divorce yourself from the case and ask yourself, was I a little bit maybe too ambitious in selling this initially to the client? What's the situation right now? What's the best thing for the client? Yes, you were the person who ended up coming up with a complaint. Yes, you gave them the expectations. Doesn't mean you back away from them, right? But it means you temper them with what could happen going forward and being realistic in that. And then, of course, 9 is one of the best things you can do is put everything in writing. Don't have a dialogue. Just tell the client, put everything in writing to what you said, what you think you owe, and what else. And then you have that written statement, set of written statements, and you challenge them. All right, I went through the fallacies or biases that are involved with the endowment costs. So we're going to move on to decision trees. Now, once you have essentially the endowment effect removed from the picture, and you've discussed the mediation economics, and you've set the structure, and you've gotten the goals of the client firmly set, all the things that we talked about before, you're now ready to put the pen to paper and to engage in a case evaluation. Again, case valuation over here does not mean that you're only considering trial outcomes or what could happen in the litigation process, because that's only very often half the picture or even less than half the picture. You have to consider everything that's gone into your discussion so far with a client up to this point. But once you've done that, you can then engage in a little mathematics, right, which is where you can take various outcomes, and I will commend everybody to this wonderful webpage over here. You can see from the materials. This is from Daniel Klein Mediation. He's a mediator out of Georgia. He put this page up. It used to be that you would be able to just generate trees right off the bat of this page. Now I think it requires you to sign up, but fear not, there is a whole set of software that's out there. You do not have to learn how to do probability analysis. So if you're experienced with doing it, you can do it in Excel yourself. But the advantage of using software is that it does all the work for you. Probably at this point right now, you probably can have AI do it for you. Be very careful, though, of course, when using AI, insofar as that if you're using a free version and you're feeding in real variables, you could have a serious problem if someone comes up with what your analysis is going to be, from doing that. So definitely make sure that whatever you do is confidential, because mediation is certainly a confidential process. But basically, the way that decision trees work is that you take a look at all the outcomes, and then you ascribe a certain percentage in probability terms. With all the outcome percentages having to add up to 100%, it's basic theory of probabilities. And from there, you can take what you perceive to be all of the outcomes involved in a litigation and then reduce them ultimately to get a settlement value. So here in this example, and I'm not going to go through all the steps, but trust me, the math works, I've gone through them. You'll see in this grid over here that in a typical case, civil litigation where you have summary judgment, it's going to be 3212 under the CPLR, 56 under the FRCP. You're going to factor that into the mix, whether or not summary judgment is going to be granted, not granted. And then from there, you would also factor in litigation expenses. As you see over here, very important to do that. That's, again, something that goes above and beyond what might be discussed in terms of a trial valuation. You're also talking about, what the costs are going to be. And then in terms of the expenses, it's not just necessarily going to be the expenses with respect to the litigation. That's what you have over here. It's also going to be the expenses with respect to daily life, keeping the litigation going. How much does it cost to run? Once you factor all of that in, you could come up with, it's called an EV, an evaluation value. That's the number that you have over here when you have don't settle. If we're doing that, and 81,000 is do settle, and that would be the value over here. Again, that's taken from looking at all the outcomes that you have over here, $175,000 low expectation for a verdict, medium being probably where the case is going to fall in terms of valuation, and then high, then essentially working that back or regressing that till you get to a number. Again, all very much done with math. Now, problem with decision trees is that they are very scientific, and that's the downfall of them, because mediation is much more an art than it is a science. Fact is that when you are engaged, again, in the mediation environment, it's not just the outcomes in litigation which is going to matter. So you have to factor that going forward. If you take a look at the caveats that Mr. Klein gives us, decision tree analysis can be exceptionally valuable, but again, as I said before, it has its limitations. It relies on very rough estimates. No one has a crystal ball, so keep that in mind. Even the mediator who's going to be doing this, you have to sometimes be circumspect as whether he or she is putting things in the right perspective. Of course, if you do your own analysis in advance, you're in a much better position. And of course, if someone's adopting a chess perspective towards the mediation process and you walk in with a decision tree already prepared for the mediator to evaluate, congratulations, you will get certain social capital with that mediator because you're evaluating the case that much more intensively and broadly than the other side or sides. Again, it doesn't also consider the parties' respective aversion to risk. That's why that question, what do you want to achieve, is so important. If you don't get the aversion to risk, and even though on paper something may look very good and might be very probable, guess what? Things happen in litigation that you don't expect. Expect the unexpected. So in that scenario, you have to make sure that your clients are well aware of that, and if they're risk averse, be careful. Don't give them a decision tree and say, here we go in and we have this much of a probability of prevailing. If the mediation doesn't work out, this is probably what we're going to be doing. Again, don't make guarantees. Okay. But you want to come up after you do your analysis, even if you use a decision tree, if you use a cost benefit analysis, whatever you're going to be using, as long as it's realistic and grounded in reality, you should be coming up with a concrete number for mediation. That doesn't mean that the number has to be written in stone. It should be something which is concrete. It's not necessarily immutable, but it should be a number that you're coming in. Not, oh, well, we're going to be potentially asking for something between $100,000 and $1 million. And let's say the amount of controversy is $500,000. Yeah, great. Mathematically, that might look great on paper, but realistically, that's probably not going to get you anywhere. Again, you have to define what the client wants and where you want to be in terms of a final outcome in dollars and cents. You have that quote there from Sun Tzu or Sun Tzu, telling you that you have to know your case, essentially, for that. Okay, with respect to pre-mediation conference preparation, all right, this is just a recap of everything that we said before. You're going to define success for the client. Success is what they want to achieve. You're going to inform the mediator that you and your clients are in a collaborative mode. You're playing Go, you're not playing chess, right? And the mediator, in terms of going into the process, will be very happy to hear that report. You're going to address any surface constraints before you go into the mediation process. What do I mean by surface constraints? Limits on authority, any outstanding liens. For those people who do personal injury litigation, you have liens which are factored into the mix. Contingency, if you're working on contingency as an attorney, you got to be upfront with your client and tell them, look, I'm going to be taking a fee of probably 1/3 off the top. And it's very important they're informed of that, because $100,000 to a client, you tell them that, and then you haven't factored for that 33% cut. There's a big difference between $66,667 and the $100,000, because again, based upon what we said with anchoring, right? You mentioned $100,000, they're going to be anchored to $100,000. So it's very important that you modify the anchor at that time and address any surface constraints before you even approach the mediator. Target information gaps. If you're missing stuff in discovery, or for that matter, just how, let's say, the financial state of a company is doing. One of the biggest questions that often is missed, how could my adversary realistically pay if I get a judgment against them? Because if you get $1 billion judgment against a corporation, and then next day, corporation goes out and files Chapter 7 or Chapter 11 bankruptcy, yeah, good, congratulations. You have something which is very attractive on paper, and it's worth just that. You have a beautiful piece of paper that's effectively going to be worth nothing because you didn't figure out whether or not a judgment was enforceable or collectible. So that certainly is one information gap that has to be there. Again, you want to also make sure that your clients, and you for that matter, are not using the mediation process to weaponize it. You want to go in with a assumption of good faith. And then you would often want to prepare a pre-mediation statement. Now, the rules sometimes will dictate what that is. If the parties can't agree or the mediator doesn't have his or her own preferences or their own preferences, if it's multiple mediators, then you do whatever the rules are going to be telling you and saying in terms of pages, how many fonts, in the 12-point font, 10-point font, whatever it's going to be, follow the rules. But if you could agree on something between you and the mediator and the other side, or if the mediator has a special preference, I certainly would recommend following that. It makes it much easier for the mediator to do his or her or their work. Here you have a sample pre-mediation statement, which I actually used in a real case where I was an advocate for a client in mediation. This was a conversion case. It was relatively simple, but it wasn't simple certainly for the client. There was about $70,000 amount of controversy, plus there was also property. Some of the property had sentimental values. The question was, how are you going to value that? Big issue, right? You not always can value money, in terms of sentimental items. You can't necessarily ascribe a monetary value to that. So here you have all of the points. I just want to highlight in my pre-mediation statement 8 and 9. Right? 8 is basically, why should I win? That I ask the client, and then 9 is the tough question. And the best attorneys who do well in mediation, and this is the test of whether or not they're really adopting a go mindset, a collaborative mindset, is why should the other side prevail? If the other side can give me a good answer, and it's unfortunate, it's few and far between. I'd say maybe 20% of the mediations that I have I gotten this. But if I get a good answer from the other side, from that attorney has a distinct advantage because that attorney is realistically assessing what's going on in the case. And that's what's very important in mediation. That attorney is trying to understand where the other side is coming from, and not just understand necessarily their position, but understand where the outcomes of the case might fall. Okay. All right, that takes us now into the actual preparation for the mediation. Is the first session. You're going to want to try to get some videos. And unfortunately, I'm looking at the time over here. I know everybody's tired, so I'm going to leave them for you to look at. All right, but I'll just tell you, I'll just announce it as part of the CLE. On the first excerpt on the NICLA ADR committee mock mediation, where I haven't participated, actually I haven't participated in the NCBA, this Nassau County Bar Association mediation. Also, both of these videos, by the way, were taken in the midst of the pandemic. We all figured as mediators, we weren't servicing clients anyway, at least in person, and Zoom mediation really wasn't that in vogue. So we got together and we did mock mediation videos in anticipation of the backlog of the courts, which did ultimately happen. So take a look at from the 13th minute, 10 seconds to 14:45 on the first one. And then on the second one for about 5 minutes. Those are just excerpts. But when you find a mock mediation video, don't just tell your client, go home, watch this. This is your homework. Sit with your client, look at the mock mediation, see what works, all right? And there are tons of videos out on YouTube besides, these are 2 Vimeo videos, but you could find, at least the first one, you could find on my website on YouTube. There are tons of examples of mock mediations. The Harvard program on negotiation puts them out. So you can certainly have plenty of material. Find one which is close in terms of the facts of your case. See what's going on, see how the mediator in that mock scenario handled that, so your clients really understand how the process works. And again, it's not something which your clients should just do on their own. Sit with them, go through it. Yes, by this point, in terms of your careers, if anybody here, how many people here are 30 or higher associates? Yeah, okay. By this point, you've probably encountered mediation. I would think it's some level or what else. Even if you've done it through before, this is a matter of client relationship. Sit through it again. Right? If your clients are experienced also, wonderful. Watch it at double speed. Right? Yeah, that's the beauty of having a video right now. You can control the speed. Watch it at double speed. It won't be 90 minutes. It'll be 45 minutes for doing that. But again, it's important that they go in, especially if you have a client who doesn't understand what's going on. You don't want clients walking in thinking, I have to persuade the mediator that I should win. Wrong mindset. And again, it's going to result in disaster. All right. I promised you Badger. Here's Badger, right? It is essentially an acronym for the entire mediation process. So we begin the mediation as mediators. This is really for mediators, but the first 2, although A has some participation with respect to advocates. But we begin the mediation with introductions and rules. If there are any ground rules, people can't speak over each other because you're in a Zoom environment. That room usually is self-enforcing in Zoom, but in an in-person environment, it becomes very difficult. In terms of ad hominem attacks, we want to get, again, the people focused away from the personal interactions between the two of them, less of a focus on the past, more of a focus on the future. Those are rules that very often the mediator will put into place. Not weaponizing the mediation process. Another rule that I have as part of my my set of rules, but that's for the mediator to worry about. A is really where you start coming in, all right? You're going to be having your case statements. You've already done your work before. You've just already submitted your pre-mediation statements. Don't think, though, that those are just in stone. Something comes up in the initial session. Guess what? Prepare another presentation. I had a case which went on for months in mediation at the Appellate Division Second Department. And I can tell you, one of the reasons why it was so successful was because the plaintiff in that case, it was a mold contamination case, she adapted. She and her attorney ended up updating the information that was provided based upon what was disclosed at prior mediation sessions, and it was wonderful. All right, so keep in mind, accumulation of information is a constant process. It goes onwards above and beyond the initial case statement or pre-mediation statement submission. D is discuss needs and interests, and this is where mediation really comes through as being different from litigation. This is where we get away in terms of the process from the chess mindset into the go mindset. A need and an interest is going to be different from a position. And once your clients understand that, the world is your oyster in mediation because things will open up. What is the difference between the two of them? I've already articulated it before. I have a need for financial security. I have a need for business certainty. I have a need to realize something on this investment. I have a need for continued employment if you're in the employment field. All of those are going to be needs or interests. Those are going to be things which the client can have satisfaction from for more than just the simple payment of money. All right? A position is, I need to have this specific piece of property. I need to have $200,000, whatever sum of money it's going to be. I need to have this person fired and never come back again. Right? Those are, now sometimes it's inevitable. Sometimes the way that the case works, you need to take positions and what else, but it's important to discuss as many needs and interests as possible. Why? For the mediator, that is the substance of bargain. Just like consideration in contracts is the substance of bargain that we have in the contractual world, so too when it comes to the go world of mediation, needs and interests are that which the mediator can use. Client feels aggrieved from something, can something else be done instead of just a mere payment of money to satisfy him or her? Can we set up, again, as I said before, in the commercial context, a profit sharing plan, stock options, whatever it's going to be. You have the sky as your limit as mediation as long as the clients are willing to go forward with that. So it's very important to get all of those out in a grid. And I'm going to show you exactly what that looks like in a minute. And then from there, we go to G, which is generate movement or options, which is how potentially can we resolve the dispute. Then there's the E stage, which for the most part, at least on the West Coast, is inevitable. On the East Coast, not always, but it's getting there, fortunately or unfortunately, which is that you escape to caucus. Escape itself is an acronym, which I'll go to in a second, but caucus, let me just define that. That's a private meeting, a breakout room in Zoom land for those people who have been in virtual mediations, where the mediator works with each side and then shuttles back and forth in your traditional shuttle diplomacy. Not all mediations have that. Some mediations have what's called the joint session, where all the parties get together and try to understand each other, and then you get understanding and you can walk away. I mean, one time I had with the NICLA attorney-client fee dispute program, just right down the block, the litigants happened to be both attorneys themselves, so it really was weird. It wasn't an attorney-client dispute. It was really an attorney-attorney dispute. One of them happened to be the client for the other attorney. And after about 2.5 hours, I asked, is there something between the two of you that you could agree upon, that you come to understanding? They think, and then one of the parties goes, yeah, I think we could both agree we want to see each other burn in hell. At which point I said, oh my God, I just walked into a minefield. Oh boy, I'm waiting for it. And the other side, I'm just waiting for him to blow up and say, that's it, I'm out of here, I'm not wasting my time. He cracks up. He just starts laughing hysterically. It's like, yeah, believe it or not, that's the first thing after the last 8 months. I think we could agree we want to see each other burn in hell. And both of them started cracking up spontaneously. 2.5 hours later, we ended up coming with a resolution. And again, because what was ultimately there was a lack of trust. It had nothing to do with the money. The case involved ultimately a 90% win of ultimately with the investment. It was a securities case of what the investment was lost on. There was no question that there was no malpractice. Now that's where one side was going for like that. But the other side felt that they were betrayed. They weren't giving like that. Once we got them to actually agree on something, everything fell from that. Their need and interest was essentially they are restoring a relationship. It would have been completely uncovered and would have gone by the wayside had they stayed in litigation. So again, you use the needs and interests to generate movement, escape the caucus. Why are you going to go to caucus? To number one, you're going to explore settlement options. That's where you do not want to be with the other side. Oh yeah, we understand the other side. Here's a settlement proposal. No, okay? At the end of the day, people still are trained as litigators. They're going to take that. They're going to get anchored by it. Not a good idea. Anything that deals with specific offers in terms of actual money should at least initially be discussed in caucuses. As signal warning signs, is there something that's going on in the background with the financial health, let's say, of one of the companies of your clients that nobody knows about, that it's time to put on the table because they simply can't pay a judgment of whatever would be? Ideally, that should be surface constraints that should be addressed before, but sometimes things happen, all right? That's not something you want to disclose to the other side. C is confer movement. You're not sure really what the other side is saying, but by saying what you're going to say, you're going to think that the other side may think you're saying something differently, so you want to take the mediator in to act as a shield. That's what that stands for. A is attack the recalcitrant parties BATNA. Anybody who studied ADR will know what BATNA stands for. Best alternative to negotiated agreement. Then that very often in the litigation area is going to be litigation. But if you want to attack the other side's idea that litigation is going to be very good for them, you don't do that with them in the room because that's going to lead to reactive evaluation. And then you'll spiral down into a circle of discussing past conduct that's not going to get you anywhere. P, pause. Sometimes time, again, works to heal wounds. You want to tell the mediator, look, I think we need to take a break, an hour, a day, a month, as I said before. And then E sometimes is evaluate. Seriously sit down with the mediator and saying, look, here's what I view as the case valuation. Here's what you view as the case valuation. Here's what they view as the case valuation. We're really far apart. Is there any way you as mediator can do something to try to bridge the gap, all right? Pun fully intended, because that's what we're here for today. All right, R then comes after that is resolve the dispute, and hopefully the parties get to the point where they're able to resolve everything. So I'll just put all of these out over here. And I was intending on discussing all of these seriatim, but I do want to give just a little bit of time for questions and answers at the end. So I'm just going to focus on the expansive variables. When you're involved in the mediation process and you're dealing with options, think about variables of things that could be put onto the table. Everybody here, what do you bring to the table, that expression? So think of the proverbial table and what are you putting up on it? If you play poker, this is the time to ante up. What are you going to put on the table? Well, everybody's putting on, because you're involved very often in court-annexed mediation, with rights, obligations, remedies, issues, and positions, because that's the nature of litigation. That's what litigation discusses. All right, everybody's familiar with those. It's the expansive variables. Those are all things which are distributive. What's the chance of your prevailing on this? What's your chance of not getting this injunction, et cetera? That very much is trial variables and classic litigation analysis. But it's the expansive variables, however, where things start to get interesting in mediation. We talked about interests before, and again, those are paramount: needs and interests, needs, desires, fears, preferences, priorities, beliefs, and motivations for the positions that people take. Trust, by the way, as I just said before, can be a huge interest. That was the case involving the two parties who wanted each other burned in hell. Values. Do you happen to notice any symmetry of values? Do they have a common religion? Do they have common beliefs? Do they have a common ancestry, ethnicity? Anything that could be used essentially as a fulcrum to get them to come together. Thanksgiving dinner with brothers who are at war with each other. Just putting that out there. What's the prospect? What would you think of a world and where you could get together with your brother, where you've been fighting for 10 years over a division of a company that was given to you by inheritance, that you ended up ceding to inheritance by your father who passed away, 10 years ago, whatever the case. What would you like to see? Could you imagine a world in which you could have Thanksgiving dinner together? All right, and very often that can come together. We have the value of that. We have the value of family, the family values. Identities, all right, that is essentially people's characteristics that define a person, including the groups that people feels they belong to. I have examples over here: Christian Democrat, baby boomer, people who've been imprisoned in a CLE program for an entire day. All right, and then of course there's power, which is interestingly enough, a lot of people think that power is a distributive variable. It's not. It really is the ability to affect change. Right? It's the ability to feel that you have some control over the environment. It's something very important, by the way, to discuss with your clients. Very often, clients are thrown into an environment where their attorneys are their gladiators. They have no control over everything. They don't know what's going on. They see the power to them. And if you can find some way in the mediation process to empower your clients, and better yet, empower the other side. That's Jerry Spence, by the way. That's not mediation tactics. That's litigation tactics. If you empower the other, you very often can persuade. All right, How to Argue and Win Every Time is a book by Jerry Spence. I highly recommend it if you're a litigator. But it works just as well with mediation. If you can empower anybody at that point, you have tremendous leverage, and it's a discussion for another time. It's exactly why that works, but it does work. Just trust me on that. One very quick rule I'll give you: the rule of reciprocity. If you make a concession in mediation, chances are more likely than not the other side will respond at either 120% or 125%. Somewhere around there. That's what psychology has told us. So in other words, if you are willing to give up some item, whether it's an aspect of a contract or if it's a certain deal, giving a credit, you can very often get that much more. You get that back from the other side. Yeah, you're willing to come forward. You're willing to put out the olive branch. I'm willing to do the same and to move on. All right. Once you've discussed all your needs and interests and you get all your expansive variables out with the mediator's help, you'll then start to create a needs and interests grid. You'll actually put them out for everybody to see, and the mediator should hopefully be able to help you do this. I happen to use an Excel file. You'll see I line up very simply plaintiff, defendant. To the extent there are alignment of the interests, that's what I'm looking for as a mediator. I'll put those into different shades of yellow. So this way, the parties can start to see that there's a possibility of commonality and agreement between them. And once they start to see that, that gives them power. Once they start to have power, they have movement. Once they have some movement, you eventually lead to creative options which are realistic. And then once you have those creative options, you ultimately should get resolution of the case. Once you establish your needs and interest grid, then again, this is done with the help of the mediator, then you would do an options grid where everybody goes down with their options. Plaintiff, defendant, you take your turns. If sometimes the defendant wants to go first, you decide. It doesn't have to be necessarily like that. Someone's going to ask, why isn't there a mediator option? Yes, all right. Sometimes the mediator will end up putting forth an option which takes elements of the other options that are there. The mediator is not supposed to put his or her or they are foot or feet on the scale. But in certain cases, if they decide to be creative and take some of the other options, maybe think of something that hasn't been done, that gets a black color, black being neutral, for doing that. But everybody puts out options. And then once all the options are out, no one judges anything. All the options have to come out. You brainstorm all the options, and after you do that, you score them. And you see over here, the plaintiff, obviously, whoever's going to suggest an option will give it a score of 0 to 100. The other side may give it substantially less, probably will, at least initially. But then you take a look at all the options that are out there. If something hits home and the parties are willing to get involved with an option that's serious, maybe a sale of one asset or trading of something else, for something which is low value to one side, which is high value to the other side, that's a process known as log rolling, then you're going to ultimately get well on the road to resolution. But if not, that's when shuttle diplomacy comes in. You've given it all the expansive variables that you have out. You then go into distributive mode. You end up just basically slicing up the pie. And that's what the mediator is useful for. But at least you've discussed everything. And by this point, each side hopefully has a better understanding of each others' respective positions, number one, but more importantly, their needs and interests. And then, God is good, right? You end up having a resolution of the case. It's very important, I'm just going to put this up very quickly, that you come in prepared. The mediator, by the way, should have this. This is really the mediator's responsibility to have a term sheet set out, all right? But if anybody's been following the news recently, there's something which is very similar to this. I'm sure it's much more expansive than what I have over here going on currently between the United States and Iran. But that's what a memorandum of understanding and a term sheet is. Is essentially you have a set out of terms in a very general sense. It's straightforward. This, by the way, is not mine. Give credit where credit is due. This is the term sheet of Magistrate Justice Karen Klein in North Dakota, if I remember correctly, where she comes from. But it was just given at an ABA session on mediation. I found it phenomenal, so I adopted it for my own firm. And it's in your materials, you can get it, but it goes into all of the basic elements of what should go into a general understanding of the deal. Then the attorneys work together to come up with a settlement agreement. But you, as an attorney, if you come, mediators again should have this ready to go. But if he or she does, or they don't, you come in with one of these and you're ready to go, you're going to, again, have a major advantage because you are making sure that the terms of the settlement, at least in the general sense, are going to be put down in writing before anybody goes home. It's very important to do this. Deals bust because even if someone says they have very explicit notes, unless it's an actual verbatim recording, which sometimes I do with the consent of the parties when it's a virtual mediation. But unless it's a list of verbatim video recording, it's always, no, that's not what I meant. This is what I want, or I forgot something, I want something else. You ask as the mediator have we expressed everything? Have we gotten everything that's out there? And then you move on and hopefully resolve the dispute. Okay. Within this, you're going to want to include, again, payment structures. This, by the way, that term sheet that I just had, it has all of this. Payment structures, timing of performance, the scope of releases, confidentiality terms, and anything necessary to resolve pending litigation and related costs. We spoke before about the joint session that very often on the East Coast is when the parties initially come together. So I give you some tips over here. Let your clients speak. Right? Don't over lawyer at this point. Don't steal their voice. This is the time where they can be heard. Maybe they will be understanding of the other side. Right? And maybe if you have a dog case, this might be your redemption to take the case out of the doghouse and finally put it to bed. Because inevitably, at some point in your careers, you're going to get a case which is a dog, which is not good for you, but either your assigning partner or someone else or someone in your family convinces you to take it, and you really don't want to be involved in it so much. And this is your chance maybe to get out of it one way or another. Alternatively, sometimes people can be very persuasive and they speak to the other side directly. Give your clients the opportunity, but at the same time, though, do protect their rights. If there's something which is confidential that you want to disclose, that's what you have a pre-mediation session for, with your client. Deal math sheets. This is something which is spoken about in that article that I mentioned before about winning the mediation versus resolving the dispute. That's Christopher Ernst. He's the current chair of the mediation committee for the ABA, for the ABA's, that's American Bar Association's dispute resolution section. Mr. Ernst recommends using these, and I'll just tell you, this is the one part of my notes where I had, So here's the definition. It really belonged above. A deal math sheet is essentially a working spreadsheet or chart that breaks down the numbers behind the proposed settlement so everyone can see exactly what is being agreed to and how it will be implemented. If you have multiple assets in a resolution, in a term sheet that you're speaking about, make sure you have a spreadsheet identifying how that asset's going to be disposed of, by when, and all the specifics that goes into each element of the deal. If it's a family mediation, for those people who practice family law, and there's issues of custody, or some people will define it as visitations instead of custody because that word has certain connotations which are negative, make sure that the arrangement is specifically set out. All right, you obviously don't want to treat a child like a bargaining chip, but for purposes of understanding, in this case, sometimes you have to go adopt that type of mindset. Key insight over here, clients who feel heard settle. Right? The need to be heard is extraordinarily important. And clients who feel talked over by their attorneys, that they don't have control, they dig their heels in because they really don't know what's going on. So by default, they just decide, I have to do what my attorney says. All right. And two other tips: view opposing counsel as a potential partner and not as an opposing force, meaning this is a person who, again, you've come to play go with. You're not here playing chess. Try to work out an understanding with opposing counsel, try to be on good terms with them. It makes for a much better process. I very often have had success where I have an attorneys only caucus. And I take the attorneys into the caucus and I say, your clients are both unrealistic. And at the end of the day, it's going to be a nightmare for both of you. And they'll say, oh yeah, we agree with, so like that. So would it make sense if maybe I speak with each one of you and them, and then just each one of them alone? Perhaps maybe I could talk some sense into them about coming down from the rafters, or at least coming up from something which is also completely unrealistic. And very often that works out. Now, opposing counsel here is a partner, is a collaborator, not an adversary. Log rolling, very quickly. I'm just going to throw this out because I know it's the end of the day. I'll give you a quick mediation example of log rolling. All right. Two children, both, let's say 7-year-old girls, are wanting to bake a birthday cake, and there's one orange. And each one of them says, I want the orange. All right, anybody want to give a suggestion about how to resolve this? Well, if you're an arbitrator, divide it in two, go Solomonic, right? Give half to one kid and half to the other. So here's the problem. Did anybody inquire as to what each one of the children wanted the orange for? Maybe one of the girls wants the orange for the juice, the part of the fruit, and the other one just wants the rind for the flavoring. Both of them could have the entire orange. All you have to do is ask. It's an example of log rolling. You're taking something of relatively low value. The one who wants the pulp has low value for the rind, and vice versa. And then you're using that essentially as an expansive variable to come up with a settlement. Yes, it's very basic when it comes to children, but believe it or not, with adult human beings, it works just as well as long as you're able to ask the right questions. Right? But again, it's a mediator tactic, but it's important as an advocate that you know how that works. Last part of this presentation, I know we're getting to the end of a very long day. So I'll just ask, anybody over here, has anybody had a mediation that's quote unquote failed? It didn't have a successful outcome? Whoa. Well, okay, good. Thank you. Okay. We have one person. Wow. I'm like, hey, I'm cheerleading mediation. I'm like, that's phenomenal. We have all right. So we have one person. Inevitably, there are going to be mediations that people call failed mediations. I personally do not believe that such a concept exists. The reason why is because any information that you get from any dispute resolution process is valuable. There is no knowledge which is not power. There's no knowledge which you have which can be used, which cannot be, there's no knowledge which you have which cannot be used to effectuate change. You learn something new just from this simple interactions. You can learn how the other side values the case. You can see how opposing counsel presents himself or herself. And you can also see opposing counsel in action, because inevitably people are going to let down their game face when it becomes 4 o'clock at an afternoon when you started at 9 o'clock in the morning. Just like over here, you get exhausted, so too in mediation, or sometimes 11 p.m. Yeah, we do go long in mediations. But the mediator also has his or her or their own perspectives on the case. So that's why I don't view it as being a failed process. It could just be something which is not resolved yet, as having a growth mindset. And very often you have one step back, can enable 2 steps forward in eventual resolution, because there are certain things you might learn in mediation that will go forward well in litigation, and maybe creating a side deal that chips away at one part of a case, and then afterwards the rest of the case gets resolved. Even if that doesn't happen, all right, you could still come up with contingencies in the litigation process. If you have to go from playing Go back to the chessboard, come back to the chessboard with an understanding of really where you can go on the chessboard in terms of maximizing value and efficiency for your clients. Example, if you decide that summary judgment is a good pivot point in the case, a good deadline in the case, you could say, here's the story. You win on summary judgment. All right, we take it to appeals, we fight there. You lose on summary judgment is denied, right? Or I don't win on summary judgment, either way it's going to go. We go back to mediation. How about that? And sometimes that'll very often be the case. The parties realize it's not worth it to litigate past that point anymore. They wouldn't have that understanding had you not started the mediation process in the first place. So failed mediations, yeah, people speak about them, but in my world, there's no such thing. Right? It's just advantages to be gained. Maybe not the advantages that necessarily you were hoping for, but there always are still there. All right, last but not least, if you have to pick a process between litigation and arbitration going forward, I highly recommend that you pick arbitration, simply because the speed. All right, I can tell you, I do litigation. You can see from my business card, I do civil litigation on the side now more than anything else. Most of my work now, thank God, is neutral work, where I'm acting as a neutral, or for that matter, at neutral advocacy work, where I represent clients in mediation or arbitration. But I can tell you, the litigation that I have a shareholders derivatives dispute right now running in Queens County Supreme that we filed in 2024 in July. And now we're running on 2 years. And I made a motion for summary judgment. And it's now been about, a year and a half, year and 3/4 since I made it. And chances are that if I were to get a decision on that motion, I'd be amazed, because the way the courts are running, it's about 3 years. There's just a tremendous backlog for doing that. We'll see. I did, by the way, offer, people who say, well, did you offer mediation? Yes, I offer mediation actually through the courts, but the other side so far hasn't been interested. We'll see how that goes, but I'll just say, if you have a choice between litigation and arbitration, and going back to it after you've done with mediation, you certainly want to go and get involved with arbitration, because it's faster, it's more efficient, and you also will have much more control over your schedules. Very often the thing in litigation, everybody goes into litigation thinking, we're going to win on this case, and especially when you start out in your career, we're going to win on this claim, we're going to win on this defense, and everything's going to be on your door. Then you see how the case moves, but then sometimes things get super accelerated. Arbitration, you set the pace. You don't have to worry about a judge's other cases on the docket. Your arbitrator is there for you. He or she is ready, or they, if you have a panel, is ready, willing, and able very often to accommodate your schedule within reason, all right, like anything else. But you're going to get much more mercy from an arbitrator on balance than you will from a judge. With that, I believe we are at the end of a very long day. So I want to thank everyone for listening to my presentation. I'll just ask, can I take 2 questions? Okay, because I was given a late start, so I asked for just a little of that on the list like this. Everybody has my information. It's at the end of the materials. If you want to send me a question by email, I much prefer email. Send me a question by email. Does anybody, you're free to go, by the way, right now, so it's like that, but does anybody have any questions that you would want me to answer over here about the presentation? No, all right, everybody, you've made it. Congratulations. Give yourself a round of applause. If you do have any questions, please. Yeah.
In the next 24 hours, we'll be emailing you your instructions on how to download your certificates once we verify.